All righty, we're going to go on the record on cause number DC 224848, Uphold Designs versus Drew Baird. Counsel, make your appearances.
Connor Nash for the plaintiff, Uphold Designs LLC.
Janet Randall for the defendant,
Marlene.
Drew Baird.
Marlene Thompson for Terrence Slattery and Teresa Slattery.
All right, did someone have an issue? I thought I heard something. No? Okay. You guys can proceed.
Your Honor, which motion do you
Your
want
Honor,
to start with?
I'm not sure what's going on. Ms. Thompson, I think you're having an issue with your internet.
Oh, I'm sorry. I'm in the hallway, actually, outside your courtroom.
Okay. Did you want
my understanding that
Miss Richardson or Eva? Do you want to go get her and have her come on in and she can use one of the iPads? She's having some problems with her internet. Eva, are you there?
Yes, Your Honor.
want me to just make my way over to your courtroom?
Yeah, if you don't mind, Eva will come get you and give you the iPad. All right, Mr.
Okay, thank you.
Who's making the argument? Who's starting the argument here?
It's my motion.
Okay.
We have two motions, Your Honor, that are being heard today.
What's the other one? The motion to withdraw?
No, it's a motion for summary judgment. It's Baird's motion for summary judgment against Uphold.
And what's the other motion?
I believe it's a motion for summary judgment brought by the homeowners.
Okay. I thought there was a motion
Both
to withdraw as well, is there not?
There is a motion to withdraw, but that's set for next Monday.
I see,
April
I
22nd.
see, I see. Yes.
Yes, Ron.
I am. Okay. This is mine.
So you got your own phone?
I did. I just didn't have a very good connection.
Well, here, can you just use this one?
Sure.
Right up here at your
Volume.
volume, and just hit the top, and then it will be for your mute.
All right. Thank you very much.
Right,
Okay,
there you go. All right, let's go proceed.
Your Honor, as I said, I believe we were the ones that the Slattery's motion for summary judgment was the one that was set for 2 o'clock today.
Let's proceed.
And we have also an objection to the summary judgment evidence produced by plaintiff. Basically, this is a breach of contract case, and they spoke very much about the contract, but failed to actually produce the contract, and therefore we object to it on those grounds as a violation of the best evidence rule.
Response?
Yes, Your Honor. There is no written contract for this. It's an oral agreement, and so I'm not really even sure what they're objecting to. there is no written contract signed by the parties.
This is a $72,000 contract for goods.
It was not for goods, it was for services.
Oh. Misread the contract that was or the invoices that were attached to the motion.
Right, whose motion, whose motion was this? I thought this was Mr. Nash's motion, no?
No, it's the Slattery's motion.
In your motion,
And this-
okay, so okay, so your motion is to
It was a motion for no evidence summary judgment, and then we objected to the evidence produced in response to that motion by plaintiffs.
Mr. Nash, your response?
Yes, Judge, they objected based on the violation of the best evidence rule.
And I'm going to deny that objection. So what else do you have? Mr. Nash, your other response?
No, that was their objection was on the violation of the best evidence rule, and that's.
Mr. Nash, do you not have any more argument here?
Are you talking about to the actual motion and the substance of
Yes,
the evidence?
actual motion.
I'm sorry. I thought we were okay. I'm sorry. I thought you were asking just about that. Sure, Your Honor. So I'll just be brief. This is the case where the plaintiff Uphold Designs improved a property that belonged to Terrence and Teresa Slattery. And the Slatterys hired Drew Baird to be the general contractor on the renovation of that home. So the plaintiff met with the Slatterys and Mr. Baird, did a walkthrough, went over what they needed, which was cabinets, drawers, I think some doors as well, that he ended up installing in that home. Completed the work, everything was done, got approval from both the Slatterys and Mr. Baird, and simply that they both said that he would be paid. The Slatterys and Mr. Baird, he never got paid. They paid a couple of down payments, but the total still owing is $74,007.50. The defendants filed, both defendants filed no evidence, but we're on the Slatterys right now. And the Slatterys filed a no evidence motion for summary judgment, which, as you know, Your Honor, just need a scintilla of evidence. Mr. Gomez, who is the sole member of Uphold Designs, attached a declaration walking through the facts, walking through how there was an agreement. Everyone said he would be paid. He was never paid. And so just with that scintilla of evidence, we just respectfully request that you deny their motion.
You want to say anything else?
I do.
Yeah, go ahead.
Your Honor, as counsel just said, we had a general contractor. We didn't have a direct contract with the plaintiff. All payments were supposed to be made by the general contractor to its subcontractor. That is their deal. We have been dealing with the general contractor, and there was no expectation that we are to be dealing with a subcontractor directly. We hired a general contractor who was supposed to be taking care of all this. And we did not have a contract directly with the subcontractor.
And Your Honor, all that's in the record is Mr. Gomez's, who's the member of Uphold Designs, declaration saying that there was an agreement between the homeowner and Mr. Gomez and Uphold Designs that he would get paid. And so that's just argument of counsel that they just made. That's not that none of what they just said was in the record. And again, it's just a no evidence motion for summary judgment. So they don't have any evidence in the record that would support what they said.
All right.
Actually,
I'm going to go ahead and deny the Slattery's motion for summary judgment. Do you have a proposed order here, Mr. Nash?
I do not, Your Honor, but I'll upload one within 5 minutes.
Okay, you need to, before you do that, you need to share it with Ms. Thompson. You need to get it over to me. It needs to say at the beginning that this was heard on April 15th, 2024 on Zoom. And you need to share that and then get that to me by tomorrow morning.
Yes, Your Honor, I will certainly do.
Let's go to the next one.
Yes, Your Honor, it's Mr. Baird's motion against the plaintiff Uphold. And Your Honor, there are several issues in this. The motion for summary judgment was filed based upon the plaintiff, Mr. Gomez, who was appearing on behalf of as a corporate representative for the defendant. During that deposition, and we've included those excerpts, Mr. Gomez testified clearly that the LLC, who is the plaintiff, Uphold LLC, did not do any work, did not send any invoices, was not owed any money. And during that deposition, counsel, who is counsel present today, Mr. Nash, had objected based upon some vagary in the questioning and answering. So Mr. Welsh, who took the deposition, clarified, again, tried to clarify to make sure it was clear that the plaintiff named in this lawsuit with the LLC did not do any work. Mr. Shaw even asked Mr. Gomez, why is Uphold LLC named as the plaintiff? Mr. Gomez says, I don't know. Subsequent to that deposition, this motion was filed seeking summary judgment. That the plaintiff submitted a reply. And a response, I'm sorry. And in that response, plaintiff submitted an errata sheet. That errata sheet was attached to the motion and it was included, and I don't know if this was an error, but the idea is it was included with a notary in the deposition transcript prior to the certificate at the end of the deposition, which was initially signed by the court reporter. That errata sheet, and we filed a reply, that errata sheet was never submitted to the court reporter in time for it to alter or, let's say, change the deposition testimony. The errata sheet is written in a manner that it's clear. Nothing's ever clear in the law, but it implies that these responses were changed, where you have to give a reason for the response being changed. They were done by the attorney. And the rules required that the responses in an errata sheet to a deposition must be done by the deponent. Mr. Nash never objected or never even cross-examined his own witness. If you look at the errata sheet, Your Honor, those answers that are changed are diametrically opposed, and they're trying to undo the damage that was done when the plaintiff answered, no, LLC did not work, did not do any work. Mr. Welsh also questioned the plaintiff on the issue of the company Uphold, and I think I'm saying this right, Uphold Designs LLC, that your company has been forfeited its charter, and it no longer has any right to bring a lawsuit or to defend a lawsuit. And the plaintiff didn't really understand any of that. He just, he answered, but the evidence was in the exhibit, and then Mr. Welsh, sorry, I keep saying Mr. Shaw. I worked for Mr. Shaw for so long, that's why I keep saying it. But Mr. Welsh attached those documents to a subsequent reply. So what we have here, Your Honor, is we have a witness who testified his company didn't do any work, at least the company that's named as the plaintiff. Didn't do any work. And even if you look at the exhibits, and we have filed a motion to strike in addition to that was included with the summary judgment, to strike the evidence. The documents that were submitted are invoices that are not, there's no foundation laid for them. They're not signed. The invoices are directed to the homeowner. Mr. Baird's name does not show up on any of the invoices, and the invoices reference a payment, and it doesn't say who paid, who made the payment. And all of the references in the motion, in the actual body of the motion, we've also asked to have those stricken, because whoever prepared the motion is making statements that are unsubstantiated. So there is no evidence in this court of a contract between Mr. Baird and the plaintiff that's named in this lawsuit. The plaintiff that's named in this lawsuit has admitted it didn't do any work. At least
okay, thank you. I get it. Thank you so much, Ms. Nat.
All right, I think that's pretty much that's it, Your Honor. So we basically are seeking summary judgment.
Okay, Mr. Nash.
Yes, Your Honor, and I just want to be clear about the procedural history of this. This motion was filed on March 1st, 2023, so over a year ago. we had a hearing on this motion on March 27th, 2023, which you denied and told us to go get discovery. Everything was before you on that motion, and you denied it. There is not a signed order. They refused to cooperate with that, and that was just my fault of not getting the ball over the finish line and getting a signed order to you. But we had this hearing on March 27th, 2023. It was denied. The Slatteries brought their motion for summary judgment and set it for today, and that's when this other defendant, Drew Baird, decided to piggyback on that and have his hearing on the same day. So just that's number one.
Well, Mr. Nash, let me just say this. You need to make sure that you follow up. If I don't need to have hearings over and over again, you gotta, sometimes things get caught in the and the cracks, and I'm not trying to fuss with you, but we have, on average 1,200 cases, each of the judges, no law clerks, anything like that. And so if an order doesn't get signed, this is not a court that doesn't sign orders. I sign orders all the time. You just need to follow up, contact my court coordinator if there's something not signed, and I will sign it. But you can't, repeating hearings because something didn't get signed is not in anyone's best interest.
No, I totally understand, and I'm not trying to put any blame. It is my fault that I didn't get the ball to the finish line. So I understand that. But they were there and they heard your order and they still decided to bring it. That was the only reason I brought that up. So number two, and a key thing that Miss Randall said was the plaintiff didn't really understand anything. Those were the kind of questions
excuse
that
me,
were
Your Honor, I object to that. I
at-
did not say that.
I
object to that.
You kind of did say it, but that's okay. I mean,
so he submitted an errata sheet to the court reporter correcting what he said, because there's a DBA in his name and then there's an LLC, and so he was just confused what actually was going on. And when they were talking about the forfeiture, the tax, all of that stuff, it was kind of mumbo jumbo legal issues for him, and that they twisted that and used that to try to say, oh, the LLC didn't ever do any work. Well, the invoices attached to our response with both the Slatteries and this Baird one show Uphold Designs providing work. There's a declaration from Mr. Gomez laying out the facts and everything that occurred. And frankly, there's nothing from Drew Baird coming back and saying, no, the LLC never did any work. I had a contract with someone else. There's nothing that they provided that they came back with to lay in the evidence that says anything like that, because it's just not true. They're just trying to twist the facts, twist what Mr. Gomez said while he was confused, and try to get a summary judgment issue out of that. And so for that reason, we ask that you deny it once more, because it's just something that they're trying to twist into something it's really not.
Your Honor, I object to the personal attacks of counsel. They're totally inappropriate here. The record is the record. And when I did say that it was only on the one question regarding the forfeiture, it was not on the other questions. Those other questions were extremely clear, and we can read into them. And the other thing is these comments being made by Mr. Nash now, if my client were in a deposition making statements that I, the lawyer, believed were 100% inaccurate, there should have been some cross-examination. There wasn't any. The errata sheet was not filed timely with the court reporter. And the errata sheet was not, when you read it, Your Honor, it was not prepared by the plaintiff individually. These were lawyerly objections in the errata sheet.
Mr.
And
Nash,
what they are,
just address the issue of the alleged untimeliness of the errata sheet.
Sure, Your Honor.
Yes, Your Honor.
If I could just
Oh, I'm
share.
sorry, are you talking
I
me or
could
Mr.
counsel?
Nash, that's on Mr. Nash.
Sorry.
Can I share my screen, Your Honor?
Yeah, go ahead.
So this is the errata sheet. Melody Monk was the court reporter that took this deposition.
Hold that up, counsel. It's hard to
As-
read.
Yeah, it is hard to read.
Sure. I think.
There
if
you go. I can read it.
Thank
that
you.
good? So on March 15th, Melody Monk is the court reporter that took the deposition, or sorry, the stenographer. And attached to that is the errata sheet of the corporate representative of Uphold Designs. So it was submitted timely
Mark,
on March 15th.
we complained of in this case.
Your Honor, I'd like to point out that email was sent at 11:53 p.m.
It's 10:11 PM, 53 seconds, but
Okay,
regardless.
I'm sorry, it was sent at 10:11 PM. And the court reporter's affidavit says she never received the affidavit or the errata sheet. And the other thing is the attachment doesn't refer to an errata, it refers to a depot. It says oral depot of Uphold Designs. There's something there. So
It's-
this piece
it
of
says-
evidence,
I'm confused. It says, please see attached errata sheet for the deposition of Uphold Design. What, I'm not sure what you're saying.
I'm looking at, Your Honor, are the attachments, the name of the file, the PDF.
Oh, oral
The PDF.
deposition.
Yes,
Your
oral
Honor,
deposition of Uphold Designs.
If you want me to pull up the exact email, click on the attachment while I share my screen, I can do that as
Sure,
well.
go ahead.
Okay.
And Your Honor, this wasn't part of the record, by the way.
So here's the email and then just a preview of this screen. Or the attachment, I'm sorry. Here's the errata sheet with his signature and the notary.
Okay. Your Honor, that's not how you submit an errata sheet to a court reporter. The court reporter has signed an affidavit saying she didn't get that errata sheet.
The court reporter was obviously incorrect, Judge, and even besides all this, their motion fails on just the declaration alone.
Your Honor, we've objected to the evidence
So
attached to the
let me just say this. I'm going to go ahead at this point I'm going to deny the summary judgment. This issue involving the errata sheet, I'm not exactly clear. I've never dealt with the issue of an untimely errata sheet and the court reporter saying that she didn't get it or whatever. If you want to file a motion to strike the errata sheet, Ms. Randall, or I'm not sure what the exact procedural mechanism, but that kind of.
Your Honor, we included that. We cited the statutory law that requires an errata sheet to be submitted within 20 days of when the deponent gets the errata sheet, and it also requires that the reasoning behind the change be provided by the deponent, not the attorney. And if you would look at that errata sheet, you'll see what we're talking about. That's not what the plaintiff. It's clearly written in a legal sense and legal terms. And if the court would like to hear those objections and the reasons for them, we can look at the errata sheet. Counsel can pull it back up on his screen that he just had.
I'm not as concerned about, I guess, how it was done, because I think that's, attorneys always. I've seen a number of errata sheets over the years. Attorneys will usually put them in the correct format. That doesn't mean that they weren't answered by the party. I'm not as worried about that. I'm more worried about, was it timely and was it provided to the court reporter?
Right, and pretty much the evidence is for the motion is in front of the court right now. Ms. Monk's testimony is one of our exhibits.
And Judge, that would be I think that's a separate hearing, a motion to strike an errata sheet. And if they want to file that motion, we can subpoena their court reporter and we'll have all of our evidence ready and we can go through that whole song, horse and pony show if that's what they want to do. But that's a separate motion that they have to file. That's not part of the summary judgment record.
Your Honor, it is.
You can't strike an errata sheet.
Excuse me.
By filing a motion.
Let her finish. Let her finish.
If you look at our motion, Your Honor, when we did the reply, we may have a motion to strike the errata sheet, and the motion and we provided the case law. I mean, we provided the statutory requirement that you have to provide the errata sheet to the court reporter within 20 days of you receiving it. Ms. Monk testified when she sent the email to counsel, and it was supposed to be due. And it wasn't, she didn't receive it. And just the email, the council just sent an email showing it was sent on at almost 11 p.m. on March 15th. Well, that's, you have to file stuff by 5 p.m.
That's not true. Just two things. You can't file a motion and a reply. You can't ask for relief in a reply to a summary judgment. That's number one. And then number two, it was filed timely. It was filed timely even with all this.
Well, we really shouldn't use the word filed. Filed is not correct, right? Because Miss Monk is not a court, so it wasn't filed. It should be sent
Correct.
and received by
provided
the
to
court
her.
reporter. So we both were mistaken in using that term.
What day was this reply filed? Was this on 3/22 of 23?
It would have been, yes, Your Honor, that 3/22/2023 response.
I'm sorry. I apologize. I mean, I'm not fussing with the clerks, but some of this stuff wasn't included. So let me read exactly what you said here. So I'm sorry, where does it talk about the timeliness of the errata sheet? Is that in here? I don't see it.
Yeah, let me find that for you, Your Honor.
I'll share a screen real quick. I assume this is the document you want to look at.
I can, could you blow that up a little bit, Your Honor?
Maybe.
If not, I'll
Yeah, I can. Let me see. There we go. How about that?
oh, there you go. Okay. Yes, if you look on page, it's the argument referring to Miss Monk's certification. If you starts on page 8, Your Honor,
Okay.
at the top. And then it goes down further. Certification was required under Rule 203. So if you go through and we start with identifying what the certification requirements were on paragraph 25, and then refer to cross-reference it to Miss Monk's affidavit, where she states the things that she does on page 9, which I think that's page 9 you're
Let's
on
see
now.
it.
Yes.
No. All right. So this is strange, Mr. Nash. So you claim you emailed it to her and she said she didn't get it.
I understand, Your Honor, but you saw the email to the court reporter very clearly happened on March 15th. She missed the email, obviously.
I'm going to go back to what I said before, and I understand that now you did provide the argument. I think at this point, to make it clear, I think if we really want to push this, when is your trial setting in this case?
I believe it's July 9th.
Yeah, it's July 9th. So I do think there needs to be a motion to strike the errata sheet. I know that you contain the language, but Mr. Nash, if I don't get additional evidence of some sort, I don't even know how you resolve this, if there's a he said, she said on this. Anyway, file a motion to strike, and we can figure it out at the time. But for now, the summary judgments are denied. And get me orders on both of them, Mr. Nash.
I will do so, Your Honor. Thank you so much.
All right, guys, you have a great rest of your day.
Thanks.
Thank you.
right, our next hearing is Tubula versus Global Oil and Gas Fixes, DC 237534. Council, make your appearances.
Good afternoon, Judge. Brian Lawton, Courtney Bowline, and Kelly Van Story on behalf of the plaintiffs.
Good afternoon, Your Honor. Michael Zellers, Christopher Stain, Jeffrey Sindelar, and Joshua Fellenbaum on behalf of the defendants, the global U.S. subsidiaries.
Okay, let's proceed.
Your Honor, defendants bring this motion relating to two deposition notices by plaintiffs directed to the corporate defendants. Let me say at the outset that defendants do intend to produce a corporate representative for deposition as agreed. The issue here has to do with the overbroad nature of the deposition topics.
Have you guys conferred on, I saw that there were hundreds, I guess, of requests. What, have you guys conferred on this at all?
Your Honor, there's a long set of emails back and forth. The answer is the parties have not conferred meaningfully on each of the topics. Defendant's position is that we've tried over and over to do that, and plaintiffs have their position as is described in the papers.
Judge, can I speak to that?
Sure.
Yeah, may it please the court. Judge, we had a hearing where these depositions were compelled, and they were ordered to occur before April 30th. They provided dates before April 30th. We noticed them for the dates that they said worked. They had our corporate representative topics for over 2 weeks prior to the hearing on the order compelling. We didn't know that they were going to quash the depots or even had objections to the topics until we got a motion to quash an order deposition on the dates they provided.
So I've already ordered these depositions to occur
before April 30th, and we noticed them for dates that they gave us. And the first time we ever found out that they had a problem with the topics.
prior to me ordering the deposition to occur.
Yes, sir. Yes, sir. They've had
Whoa,
those topics.
let me finish, Mr. Plotman. Let me finish. So prior to me ordering that deposition or these depositions to occur, did Mr. Zellers have a copy of all the topics?
Well, the answer is no, Your Honor. The plaintiffs were still reviewing and revising their topics until they filed their deposition notice within 3 court days after we filed this motion to quash. The parties have gone back and forth in terms of corporate representative depositions. The defendants have agreed to produce witnesses. We've agreed on dates. This was Judge Craig who issued the order. She issued an order that the corporate representative deposition should go forward before the end of April. She did not rule, and there was no discussion in terms of the topics or whether or not the topics were proper. Going back to the end of last year, the defendants have always said that there were issues with the proposed deposition topics, and that the parties needed to meet and confer over those topics. So, that's where we're at, in that it's the defendant's position that the topics are overbroad, not reasonably particularized, and it's impossible for us, at least as to some of the topics, to prepare a witness on.
Mr. Lawton, is that correct?
No, sir, Your Honor. Here's the true facts are these. With the exception of 5 topics, they've had our corporate representative topics since early January, 2 weeks before the prior hearing compelling. At no time did they say, we've got issues with these topics. We may need to be heard on objections. To this day,
Mr. Lawton, let me make sure I understand what you just said. So you said they had all the topics except for 5. Is that what you said?
Yes, sir, Your Honor.
Mr. Zellers, is that correct?
No, Your Honor. We had topics. We went back and forth, and we indicated there's been 25 pages of emails in terms of the back and forth on this. The plaintiff said they were going to finalize their topics, but the first time those topics were finalized was 3 court days before this motion was filed, which was in early March of this year.
Mr. Lawton, how did you share these topics before? Did you give them a proposed notice, or kind of how did you?
Yes, Your Honor. We sent them a draft notice in early January, a couple of weeks before the hearing, saying, here are the topics that we anticipate talking about so that you can educate a corporate representative. And we, to this day, Your Honor, after noticing these depositions for dates that they agreed to within your order, they're not taking the position, Judge, oh, we've got a problem with a few of these topics. They have filed a motion to quash to foreclose the deposition from even going forward at all. The dates they provided to us, in our view, were completely illusory. They provided us dates. They knew the topics before the prior hearing.
So let's do this. We're going to rule. I'm going to look at the 5 new topics and I'll rule on those.
All right, Your Honor, may I share my screen?
Sure.
So in terms of the topics, and we'll just go through
the 5 new topics.
Well, I don't know what the new topics are.
Mr. Lawton, go ahead and share your screen to show me the 5 new topics.
Yes, Your Honor. I'm getting Courtney to help me sitting in my office. If you'll just give me 1 second.
And Your Honor, as they're pulling that up, the defendants from the very outset said that we needed to meet and confer on these topics. So by no means did the defendants agree at any time that these topics were proper. And if I could show you the first 5 topics, I believe that illustrates the point.
I want to see that, Ms. Boland, I want to see the 5 new topics.
Thank you for your patience, Judge. We're working on
thank you, Your Honor.
Exhibit D to our motion, Exhibit D to our response. We're working on pulling that up.
Sure,
Thank you
Your
for
Honor.
your patience.
Sorry, Exhibit B to our motion is the draft topics that were sent.
I just want to see the 5 new topics.
Give me 1 second.
Your Honor, as they're doing that, let me just reemphasize the point that the defendants are prepared to produce a corporate representative as had been agreed.
Okay, great. Ms. Boland, I do have other hearings, so if you guys want me to hear this today, I need to see these topics.
Okay, here we go. So, Your Honor, 1 through 5 that were just referenced by Mr. Zellers are the same as they were in the initial notice.
So I just need to see the
Yeah.
5 new topics that Mr. Lawton referred to. That's all I want to see right now is the 5 new topics. Do you know which ones those are, Mr. Lawton? You said there's 5 new topics. What are they? Mr. Lawton, are you there? Mr. Lawton, can you guys not hear me?
We can hear you, Your Honor.
Okay, Ms. Boland, can Mr. Lawton not hear me? All right, guys, I may need to pass this hearing if you guys can't show this to me.
Your Honor, we're prepared to show you the first 5 topics just as an illustration and to make the point that at the first opportunity we had to object and to file a motion was when we got the final topics from the plaintiffs, and we immediately filed this motion to bring this issue to the court.
All right, Ms. Boline, you are not able to share the 5 new topics. Ms. Boline, I'm not clear. They're not responding to me. Ms. Boline, can you hear me or not?
We can hear you, Your Honor, so I don't know.
Your Honor, I'm
We
sorry,
can-
this is taking me, it's taking me a long time because of the way that we went through these. Yeah, they're kind of categorized, so it's not so neat and clean.
All right, what I'm going to do then, if that's not the case, I thought I had kind of an easy way to do this. I'm going to just put you
Yeah,
guys.
can we go in a breakout room for what, or can I have 5 minutes, Your Honor, and then I can come back and give you these?
Now I'm going to have you go into a breakout room with opposing counsel. You guys try to work it out, and then you can come back here if you need to.
Judge, just a short circuit. Judge, can you hear me okay?
Yeah,
Can you hear me, Your Honor?
I can.
Can you hear me, Your Honor?
Yes, I can hear you.
Just to short circuit this, we're willing to waive the 5 topics that we added and go forward with the notice they've had since January if that resolves the issue.
Your Honor, if plaintiff's counsel can't identify the 5 topics, it's impossible for the defendants to do that. And as I stated at the outset,
So this is the deal then, Mr. Lawton. You have 2 choices. One, you guys fight over all of this. The alternative is that you can have the topics will be the ones you provided to opposing counsel prior to the hearing with Judge Craig. So which do you want to do? Do you want to fight over all of these and then come back to me? Or do you want to go with the topics that were provided to them prior to the hearing with Judge Craig?
No, sir, I don't want to fight over every topic. We're happy going forward with the notice as it was when they had the original topics prior to the hearing. And
With Judge Craig. With
And
Judge
you're-
Craig.
Yes, Your Honor. And be
Your
more.
Honor, let me note for the
Go ahead.
record that those topics are objectionable. They are impossible to respond to. They're grossly overbroad, and that we ask that our objections be heard and that there be some review of the topics before we need to subject a witness to try to answer impossible things.
Judge, can I please respond to that?
Briefly.
Real briefly, number one, they're saying it's impossible to produce a representative, which that's not an objection under the case law, but they filed an 83-page counterclaim with 12 causes of action and 20 affirmative defenses. Our notice goes straight through their pleading. And if you look at the USAA case, Texas Supreme Court, I'm referring to page 792 of the opinion, USAA 624 Southwest 3rd, 782 on page 792 of that opinion, Texas Supreme Court case 2021. They said right out of the opinion that asking about legal defenses that are pled and allegations in a pleading are fair game. In this case, they compelled a corporate representative of an insurance company in a uninsured motorist case. And the only topics they said that were off limits were when the plaintiff was trying to go into extra contractual bad faith claims and underinsured motorist claim. They held, look, you're not there yet. It's premature. As you know, in UIM cases, you got to prove the underlying liability. They said as long as the topic is anchored to something in the pleadings or in discovery, it's in dispute, that's fair game. But we can't go through each topic. We don't have objections. They've never served objections. All they did was move to quash, and they're taking the position, the whole deposition that's already been ordered is off limits. I'm happy to go forward with the deposition on the topics as originally provided to them. I'm happy to amend the notice and go back to the original notice in the interest of getting it resolved and going forward with the depositions that we've been asking for since November and that were compelled to happen before the end of this month.
All right, go ahead and prepare an order for me, Mr. Lawton, indicating that. Make sure that it says that this was heard on April 15th, 2024 over Zoom. Share that with Mr. Zellers, and you guys have a great rest of your day, okay?
Thanks, Judge. Have a great day.
Thank you guys. All right, is everyone here on Blue Racer Midstream versus Procarza?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor, hold on, I think we got a focus issue on our camera.
Oh, wow, that is
There we
weird.
go. I think it's because we blurred our background.
Okay.
Much better.
That's very strange looking. All right. Sounds good. All right. Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 217310 Blue Racer Midstream LLC versus Procarza USA Inc. Counsel, make your appearances.
Good afternoon, Your Honor. Elon Rosenberg of Freewald Law, along with my co-counsel from Gordon and Reese on behalf of the movements here, Industrial Procarza and Procarza Tube and Pipe.
Yes,
Your
Your
Honor.
Honor. Jason Irvin with with Elon for Industrial and Tube and Pipe.
Your Honor, Mary Ellen Smitherman and Chad Arnett for the plaintiff Blue Racer Midstream LLC.
Can you say that a little slower? I didn't catch your name. I'm sorry.
Mary Lynn Smitherman and Chad Arnett for Blue Racer Midstream.
Could you spell your first name?
MARYLYNN, all one word.
Okay.
Mark Stedman for third party defendant, Steel Professionals.
All right, let's proceed.
Thank you, Your Honor. We appreciate the court's indulgence today. My clients, Procarza, Industrial Procarza and Procarza Tube and Pipe, were the manufacturer and seller of certain API rated pipe to the plaintiff. They sold this pipe to the plaintiff through an intermediary, Steel Professionals, who's represented by Mr. Stedman. And in the course of effecting the sale, which was effected exclusively by Tube and Pipe, which is the US-based entity, they disclaimed all implied warranties except for the specifications laid out in the purchase order. Specifically, there is concededly an express warranty that the product will comply with specifications. And as part of the terms and conditions of that same transaction, they limited the remedies available to any purchaser to either replacement in the event that the pipe is not as warranted, or alternatively to in the option of the seller to reimburse the purchase price of the pipe. These terms are simple and standard in the industry, and they're consistent with, they're not consumers, but other commercial entities in the business that are looking to acquire products at the lowest possible price. After this pipe failed, we'll concede for purposes of today's hearing that the pipe failed and there was a conclusion reached by experts retained by the plaintiff that the pipe simply failed to meet API standards. Nevertheless, the plaintiffs in this case have filed suit. And by the way, let me add an additional point, that the only segment or the only item that was damaged as a result of this fracture was the pipe that's alleged to be defective itself. Nothing else had to be removed. Nothing else had to be replaced. And the corporate representative of the plaintiff conceded that the only piece that was damaged, physically damaged, was the actual pipe that's at issue in this litigation. Under Texas law, when a product that's sold between, in this particular case, two sophisticated commercial entities, when that product is sold and ultimately fails, but does not cause injury to any individual and does not cause harm to any property other than the item itself, the economic loss doctrine controls and any tort claims are preempted under the UCC. Our motion here today, Your Honor, is to narrow the issues of this case as the record evidence has now demonstrated. And that is, there was a product that was sold as supposed to conform to API standards. The allegation is that the product failed to conform to API standards and failed. Therefore, the remedies that are available are those enumerated by the UCC and nothing else. That's settled Texas law There is no individual that was injured. There is no other property that was harmed. Additionally, of course, we are seeking enforcement of terms that are clear and concise on their face, which are the terms and conditions of sale that Tube and Pipe supplied to steel professionals when they sold the pipe. And as I mentioned, they disclaimed any implied warranties, and they limited the remedies available, both of which are entirely consistent with Texas law. In fact, they're expressly recognized under Texas UCC. The only question presented, in my mind, the only question that could conceivably have remained open prior to the close of discovery is what the terms and conditions of sale were as between Industrial and Precarza Tube and Pipe. And those terms, we have come forward with competent evidence in the form of a declaration laying out that the terms and conditions of sale as between the manufacturer and the importer who ultimately sold the pipe were identical. In other words, there was a disclaimer of all warranties except for conformance with the specifications, and there was a limitation of remedies available to the importer as well. Under Texas law, those terms and conditions travel with the product, and they are binding on the ultimate consumer. Indeed, the reason why the ultimate consumer can sue defendants further upstream is because of warranty law in Texas. Otherwise, they would lack the privity required to be able to file that suit. And in deference to the UCC, Texas law acknowledges that just as privity is not demanded of the plaintiff also must acknowledge the terms and conditions that govern the transaction throughout its entire stream of commerce. So we've asked Your Honor to enter summary judgment on all but one of the claims, and I do want to make that very clear. We asked for summary judgment on all but one of the claims that Blue Racer has asserted in this case, and that is the claim for express warranty. We concede that we warranted the product would conform to API standards, and for today's purposes, let us say that the pipe failed because it failed to conform to those standards. However, the disclaimers are established on the record. There is no evidence whatsoever, Your Honor, to rebut the terms and conditions of sale as between Industrial and Tube and Pipe. And because there is no damage to anything other than the subject pipe itself, the economic loss doctrine bars all of the tort claims asserted in this case, namely a claim for negligence, a claim for strict products liability, and a claim for negligent misrepresentation.
All right, response?
Thank you, Your Honor. We filed objections to defendants or the move-in's summary judgment evidence, specifically with regard to Exhibit N, the declaration of Mr. Villarreal. Your Honor, I don't know if you would like us to argue that or if you would rather take it under submission, but just for the record, I would like to note that we object to that evidence and would argue that—
What is the objection?
Your Honor, we have 4 objections to this testimony for 4 paragraphs of Mr. Villarreal's declaration on the grounds that they are impermissible legal conclusions, a self-serving statement by an interested party, a conclusory statement unsupported by fact, and also are hearsay to the extent that they attempt to paraphrase or discuss by reference terms and conditions between Industrial and Tube and Pipe, which have not been produced in this lawsuit, despite multiple discovery requests seeking documents supporting those terms and conditions. Therefore, any declaration attempting to suggest the existence of these terms and conditions or set out these terms and conditions by way of testimony is not appropriate, and they are not competent summary judgment evidence.
All right, response?
Yes, Your Honor.
Go ahead, Jason, go ahead.
Mr. Rosenberg is here, Parag Viche, and has asked me to address the Texas law considerations with regard to the admissibility of the affidavit. And let me take Ms. Smitherman's arguments one by one. First, she says there are legal conclusions in this affidavit. In fact, they're factual conclusions because the statements he makes say the terms of our agreement, the terms in our understanding between Industrial and Tube and Pipe were identical to the written terms that Tube and Pipe put forth to its customers. And he says that based on, they don't object to his foundation, which is based on the fact that he is an employee and he has personal knowledge and he uses those terms, and also based on his status as the corporate representative on behalf of Industrial, who also verified their discovery responses. Ms. Smitherman, so he's talking about factual issues, not legal issues. And the next thing she makes is that they're conclusory statements. They are not conclusory legal statements. If you look at the case law they cite, it's a case where an attorney is using an affidavit to get summary judgment over a malpractice case where he says, I acted correctly and properly and I didn't breach any of my duties. That's not what Mr. Villarreal is saying here. He's saying the understanding between these two companies was that these terms and conditions would apply. He's also, another important point of this is that the Texas Supreme Court makes a big deal about, as long as the affidavit, which is contemplated in 166 C, is that you can use an affidavit to support your summary judgment, as long as you had the opportunity to controvert it with evidence, then that's good enough. It can be self-serving as long as they had the opportunity. Of all the interrogatories they asked, not one of them asked what were the terms between these companies. They did one RFP on that. There is no responsive document. There's an understanding between these two companies. And so nothing in their discovery aims at this. And they also chose not to and did not depose the corporate representative of Industrial. So all of Ms. Smitherman's arguments do not make this document inadmissible. And so in that sense, I think that those arguments fall flat on their face. And the key document here is in our opposition. The key case is Trico Technologies, is the Texas Supreme Court case that I was referencing, which is 949 Southwest 2nd 308. And I'll leave it with there because I know we have some more complex arguments to hit. But I do think this affidavit is squarely within the strike zone of what's permissible in a summary judgment hearing.
And Your Honor, just to add one more point, which is not necessarily an evidentiary issue, but it is related to the substance insofar as my friend Ms. Smitherman just raised, and that is whether or not there is a writing evidencing them. The fact of the matter is that under, excuse me, under Business and Commerce Code section 2.316, there is no requirement whatsoever that the terms and conditions as between the manufacturer and the seller be committed to writing. In point of fact, section C3 of the UCC, of section 316 of the UCC, specifically says that implied warranties can also be excluded or modified by course of dealing or course of performance or usage of trade as between the parties. There is absolutely no requirement that the disclaimer between the manufacturer and the retailer, let's call it that in this particular case, be committed to writing. And the reason is simple and sound. These companies are engaged in regular, or at the time were engaged in regular, consistent transactions, had a very clear understanding what the terms and conditions of their relationship was. And frankly, the only evidence that the plaintiffs have offered in rebuttal is a series of invoices. But invoices are not contracts. And invoices do speak to one particular term of a contract, which is usually the price. But invoices are not themselves contracts and are incompetent evidence to rebut a clear, concise, factual declaration on the part of the legal representative and person in charge of the company that's at issue here. The fact of the matter is, the plaintiffs do not, and I apologize for switching to defendants, that's my bias as a plaintiff's lawyer, but the fact of the matter is that the plaintiffs cannot come forward with any competent evidence to rebut this declaration to no fault of the moving defendants. They simply were not asked what the terms and conditions were as between industrial, and tube and pipe. And that should be the end of the matter. And I'm sorry, Ms. Smitherman, I appreciate that you were very respectful of my time, and I'll defer back to you.
Thank you, Your Honor. May I, thank you, Mr. Rosenberg. Your Honor, may I have a brief moment for a rebuttal?
Sure.
Thank you. Your Honor, it's difficult to understand how these 4 paragraphs, which, if Your Honor, if it would be helpful for you or helpful for the record for me to read these paragraphs, they're fairly short, 2 sentences each, or at the maximum, just so you can understand the context of the fact that these are entirely hearsay and are absolutely addressing legal conclusions or factual conclusions, conclusory, unsupported statements of fact. For example, the first of paragraph 8 states, since 2018, all sales affected by Industrial to tube and pipe have been subject to a single express limited warranty, compliance with specification. Industrial disclaimed any and all other warranties. The existence of and the disclaimer of a warranty is a legal conclusion. And additionally, the existence of a term and condition, particularly the disclaimer of an express warranty, that has to be in writing. That is an explicit requirement for disclaimers of warranties, particularly with express warranties. Second paragraph, paragraph 9. Since 2018, Industrial sales to tube and pipe were also subject to a limited remedy in the event of non-compliance with specifications, replacement of the pipe or reimbursement of the purchase price. This is reading out a state or a term and condition of a contract without the contract itself. That is hearsay. Paragraph 10, Industrial authored the terms and conditions of sale that it required tube and pipe to offer its customers for industrial manufactured pipe sold in the United States. And that indicates that there is a writing. Paragraph, and it's also hearsay, and also regardless of whether or not Industrial authored tube and pipes terms and conditions, it's also irrelevant. Paragraph 11, and this is the most important paragraph with regard to the disclaimers of warranties, and the paragraph that the movements rely on in stating that Industrial disclaimed warranties or are subject to the same terms and conditions. Paragraph reads, the terms and conditions of sale that govern tube and pipe sales to its customers in the United States are identical to the terms and conditions that govern Industrial sales to tube and pipe. If they are identical, that indicates that there is a writing. That writing has not been produced because these terms and conditions of sale are explicit. And for Industrial to attempt to incorporate by reference and by declaration the terms and conditions of a sale without providing us with the actual terms and conditions of sale, that is hearsay. The existence of a warranty, that is a legal conclusion. All of these are contained within 4 paragraphs of a declaration that should not be considered competent summary judgment evidence.
Your Honor, could I still reply to that briefly? And I promise to be brief.
Okay.
In discovery, Blue Racer inquired about writings, and they inquired about terms and conditions, regardless of whether they were documented in writing, with respect to multiple parties. The one relationship they asked no questions about whatsoever was the terms and conditions as between Industrial and Procarza Tube and Pipe. I'm sorry to take issue with Ms. Smitherman's assertion that terms and conditions and disclaimers of warranty must be in writing, but that's not my point. That's the Texas legislature that has made that point. They need not be in writing. They can be a matter of course of conduct, course of performance, or usage of trade as between the participants. It's not my argument, it's the argument of the legislature. They decided to enact the UCC in the form that they did. And when they did, they allowed parties, particularly parties that have close commercial relationships, to govern their relationships in the best manner possible to advance their commercial interests. The fact of the matter is There is a reason why there's no competent evidence to rebut this declaration, but that does not mean that this declaration is incompetent evidence, that it is conclusory in any way. The fact is, the existence of disclaimers is a fact question. The scope and the meaning of those disclaimers is a matter of law for the court. But the existence of an agreement is a question of fact. And that is one that is established. That is one that they have no evidence to rebut.
Did you want to say anything else about that?
Yes, Your Honor, only with regard to the fact that, particularly with regard to express warranties, Mr. Rosenberg is incorrect. The case law is clear that express warranties must be in writing. They must be explicit, they must be clear. And the Texas legislature and the case law on that fact is absolutely consistent. Now, with regard, hold on, Mr. Rosenberg, thank you.
Sure.
I would just, Your Honor, the discovery requests that Mr. Rosenberg relates to are not the only ones that exist. We have asked for the terms and conditions and any writings that would automatically include the terms and conditions between Industrial and Tube and Pipe, even if we hadn't specifically asked for that, which we did. We specifically asked for any documents or any writings, any terms and conditions that would reflect those terms and conditions between Industrial and Tube and Pipe. The only documents that we have effectuating a sale between Industrial and Tube and Pipe are the invoices, wherein there are no terms and conditions on any type of disclaimer of warranty, other than, and the only warranty, the warranty provided in those invoices, and those invoices can absolutely reflect the express warranty provided by a party, is that the pipe would meet API 5L-X65 specifications. And Texas law is clear that at the point of original sale, and Your Honor, I'm getting a little bit ahead of myself and getting a bit into the merits of our response.
Just so you know, you guys only have 10 minutes left on this argument, so we can keep arguing over this.
Okay, Your Honor, I think that the case law is clear, and I think the facts, the declaration speaks for itself in that it is objectionable. With that, I will leave it to Your Honor's consideration on the ruling on that.
I'll take it under advisement. Why don't you get to the merits?
Thank you, Your Honor. I'm going to have a presentation for us that I can share just to keep myself on task. Sure. Right. So, Your Honor, this lawsuit, as Your Honor is undoubtedly aware with the amount of times we've been before you, this case arises from a failure of a natural gas pipeline that Blue Racer constructed. The pipe was manufactured and sold by Procarsa SA de CV, Industrial Procarsa, and Procarsa Tube and Pipe. On the eve of trial, the movements Tube and Pipe and Industrial are attempting to escape liability on two of their affirmative defenses. First, claiming that neither of them warranted the pipe at issue, excluding the concession that they provided an express warranty on the specifications of the pipe. Additionally, the movements misapply the economic loss doctrine to these undisputed facts and claims at issue in this case, and the economic loss rule is clear, does not apply. In summary, the motion has no merit, and this case should proceed to trial. I won't belabor the point on the facts other than the API sets out specific standards for the production of oil field pipe, and it's incredibly important for consumers or end users like Blue Racer for the pipe purchased to comply with API specifications. For this particular case, it was specifications for natural gas pipeline, which is the API 5L-X65M PSL2 specification. For shorthand, I'll call that the API 5L specifications herein. Each of the defendants expressly warranted in numerous different places, and the case law in Texas is clear that an express warranty can exist in technical writings as well as within a contract. For Procarsa SA to CV, not a movement in this case, but relevant for the sake of argument, Procarsa SA to CV expressly warranted through the stenciling on the pipe and through the mill test reports by its designation that the pipe was API 5L-X65. Likewise, Industrial affirmed those express warranties by shipping the pipe with those stenciling and shipping the pipe with the mill test reports. In addition, for Industrial's shipment documents, the packing list, the informative cargo, which is a loading report, each reflect that the pipe was supposed to be X65. Likewise, in Industrial's invoice to Tube and Pipe, once again reflected that X65 specification, as well as in this carga de salida, or it's like an exit report, is a packing report as well, indicating that X65. Likewise, Tube and Pipe in selling the pipe, once again expressly warranted that the pipe was API 5L-X65, as well as in its quote. This is the document that movements refer to in their motion. It also contains those terms and conditions that Industrial attempts to rely on. Note that this quote states that the material will be in accordance with API 5L. And then finally, an invoice from Tube and Pipe to Steel Professionals, once again reflecting that X65. As has been the point has been belabored that the pipe ruptured. The rupture of the pipe not only damaged the specific pipe section, but it damaged the entire pipeline. Defendant's counsel is incorrect in their statement that no other property was damaged. The specific line of questioning in the deposition of Mr. Gurnia, the Blue Racer corporate representative, was whether or not personal property had been damaged. That is not the case here. We have damage to the real property and to the pipeline itself. The pipeline was completely inoperable after the rupture, and to restore the pipeline to operation, plaintiff had to dig out, drain the pipeline area of expelled water, dig it out, cut the ruptured section, necessarily damaging the sections next to the ruptured section so that they could replace the defective section. As is belabored, the point, I think this has been conceded at least at this point, that the pipe did not meet API standards. For sake of brevity, I will skip this section. We all understand that they are moving on their affirmative defenses. Here, Industrial and Tube and Pipe both attempt to rely on a disclaimer of an implied warranty provision in Tube and Pipe's terms and conditions of sale with Steel Pros. As for Tube and Pipe, as has been conceded, these terms and conditions do not waive its express warranty, rather they affirm it. For Industrial, these terms and conditions don't apply to Industrial as the upstream manufacturer. Move-ins rely on Van Engines and Components Inc. versus Shows to support their argument that a downstream retailer can disclaim a warranty of an upstream manufacturer. This is 434 Southwest 2nd 132. That is not what this case stands for. This case discusses that when a manufacturer at the point of original sale does not disclaim a warranty, that warranty travels down the stream of commerce. Likewise, if at the point of original sale, the manufacturer does disclaim that warranty, that disclaimer of warranty travels down, and no subsequent purchaser can get a better warranty than the original purchaser. That is not what we have here. The case we have here is much more similar to Clark v. Delaval Separator Corp. 639 F. 2nd 1320 5th Circuit, wherein an upstream manufacturer attempted, much like Industrial, the upstream manufacturer attempted to rely on a disclaimer of warranty made by a downstream retailer like Tube and Pipe. In that case, the Fifth Circuit held that unless the downstream retailer, Tube and Pipe's terms and conditions explicitly referenced the manufacturer, that manufacturer could not rely on a downstream disclaimer of warranty. That is what we have here. Now, Industrial attempts, as we mentioned earlier, to rely on incompetent evidence of a disclaimer of warranty of sale and its sale of the pipe to Tube and Pipe. But Tube and Pipe, there's no evidence that there is a disclaimer of warranty in either through the course in commerce or the non-explicit, non-express disclaimer Mr. Rosenberg suggested exists, or through an express writing, which clearly does not exist, and I think has been conceded by the other side as an express, explicit, written disclaimer of warranty, either implied or expressed, does not exist. So accordingly, the implied warranty claim should not be dismissed because Industrial has no evidence that it disclaimed its implied warranty of merchantability and fitness for a particular purpose. And Industrial has no evidence, no competent evidence saying otherwise. With regard to tube and pipe, we have non-suited the implied warranty for tube and pipe claim, recognizing the waiver within the terms and conditions. So the claims here that are still live and still pending is the implied and express warranty as to Industrial and the express warranty as to tube and pipe. Yes, Your Honor. And with regard, the next would be the economic loss rule. Sorry, I lost my screen share. So next we turn to Movement's claim on the economic loss rule. The economic loss rule, they are correct in saying that it bars recovery in tort for a defective product that only harms itself. Here, the defective pipe section caused damage to the entire pipeline and to the surrounding area. It is critical to note that none of the cases that movements rely on are instructive or applied to this situation. I won't belabor the point. I think it's clear in our briefing, and I lost my screen share again. Apologies.
Ms. Peel, are you here for the 315 hearing?
Yes, Your Honor, for the 315.
Do you guys still need that hearing?
What's that?
Do you still need the hearing? Is it still going forward?
I mean, I thought it was the court's request that we appear for the hearing, but it is a default judgment, a no answer default judgment.
Okay. So you do still need the hearing?
Okay.
Is that right?
I believe so. I mean, yes.
Okay. All right. I'm going to go ahead and deny the summary judgment. Let's just kind of look at you guys are number 2 on the docket. Have you guys talked to the shift key folks to see, they're ahead of you on the docket. Have you talked to them yet to see if they're actually going? They're specially set.
No, Your Honor, we haven't, but we're happy to reach out to them today to see how they're doing.
Okay. Do you need the contact information for them?
That would be wonderful. Thank you.
Okay, so the name of the case, you guys are number 2. It's Shift Key versus the Riverview Nursing Facility. It's DC 21-14491. Logan Adcock is the plaintiff's attorney. He's over at Munch Hart. The number is 214, and this is off the record, Tony, 214-855-7500. Defendant is represented by Carl Schurz. And he's over at Lock Lord. His number is 214-740-8000. And so you guys are just FYI are number 2. So have you guys exchanged motions and limines and exhibits yet, or are you still working on that stuff?
We've exchanged exhibit lists. Our counter designations and objections are due today. I believe we also, Mr. Urban, offline, we can talk about the deadline for tomorrow on stipulations, I think, but we can always deal with that offline. I know the court has another case to get to, but we are working towards and anticipate being ready for trial.
Yes, Your Honor. It's been as always been a professional setting here, and they've been professional and courteous to us, and I'd like to think vice versa. So we're working on both sides as to resolving exhibits and all those things. We'll be filing 1, maybe 2 motion and limines that are very simple and straightforward, but that's it. Probably just 1.
Did you submit an order for me on this?
Yes, Your Honor. We filed an order denying earlier this afternoon.
This afternoon, let me see.
Maybe late morning.
I got it. Let's see. All righty. You guys have any questions about the trial setting?
Believe so, Your Honor. I had one, when it comes to motions and limine and ruling is on exhibits. When does the court prefer to do that? Do we do that? I assume that we come in the morning of and we start seeing prospective jurors, or how does the court handle those?
So typically what I do, and it kind of depends on the complexity of the case. What I like to have on cases that are a little more complex is a notebook that includes the motion in limines, the exhibit list, and the most recent witness list, and any other pretrial matters you needed me to rule on, with the exception of line and page designations, which I wanted a separate binder. For the binder on the line and page designations, I would like that to, for both sides, to include the deposition. So have the depositions with the designations, objections, and ideally have the deposition highlighted with on the side what the objections are, so that I can easily find them, and I can rule on whether. Are there going to be many deposition transcripts that we?
There's only a handful, Your Honor. We've already prepared the highlighted version that started on that, so that's not a problem. We'll put that in the notebook with the formal paperwork, but I understand that no judge wants to have the designations in one hand and the deposition unhighlighted in another, so.
Yeah, just have all the depositions and objections and all that stuff highlighted all in one binder.
Yes, Your Honor.
Are you gonna? I'm sorry, I didn't mean to interrupt you. Go ahead.
Yes, Your Honor. We'll get that to you. It's in the works.
Yeah, I just need it on the day of trial. And then, are you guys gonna have any Zoom witnesses?
I don't believe so, Your Honor.
We don't know quite yet, Your Honor, but we hope to know within the next 24, 36 hours, whether they'll be a person or.
If you have any Zoom witnesses, a couple things to be aware of. We have brand new equipment. When it's working, it works really well with Zoom witnesses. If the judge knows how to use it, and I'm pretty proficient in it. We have had some glitches in it lately, but when it works really well. If you want to have one of your tech people or one of your young lawyers look at it, we have a video that describes how to use the new equipment. It's very different for Zoom. It's on my court webpage as well as the county's court web pages. And so I'd highly recommend, if you have someone who's going to be doing it's the big changes for Zoom witnesses. Everything else is pretty similar to what we had before, but the big changes for Zoom witnesses. So I would definitely, if you think you're going to have some, you might want to look at that. But yeah, I don't need the stuff until the day of trial. And there's, it's less than 50-50 you're going, since we have the special setting, but you never know. I would keep in contact with them, because that'll give you a better idea if you're actually going to go, but you definitely will be called down. So you're going to need to be ready for trial.
Yes, Your Honor. One other question, if the court will indulge me, if witnesses need a translator, does the court provide that, or can the plaintiffs, Blue Racer, and us agree on a translator that we pay the freight for? I mean, how would you like us to handle that?
Typically on cases like this, you have to have is it Spanish or another language?
And
yeah, just as long as you use a certified translator, that's not a problem. So the other side doesn't have to agree on it, as long as the person is certified. I've dealt with this area pretty extensively. If you don't have a certified translator, then the other side and they don't agree, then you don't get a translator. So you need to make sure they're certified, court certified. I don't know if that answers your question. If you wanted the court to provide one, we can, but it's not ideal, because the person doesn't show up live; they show up by phone, and so that can be pretty difficult on a jury trial.
Yeah, yes, Your Honor. We'll provide one should we need one.
And this is a jury trial, right?
Yes, Your Honor.
And I know that there was some appellate issues. What is the status of all that?
We heard from the Court of Appeals this morning, Your Honor. The Court of Appeals denied Procarsa's emergency motion to stay the case. So okay. Procarsa SADCB will proceed to trial along with the other defendants.
Okay. Anything else, guys?
No, Your Honor.
We will see you guys in a couple weeks. And if anything changes, would there be any use in sending you guys back to mediation again? Do you think that would be helpful, or anyone think that would be helpful?
No, Your Honor, we don't, because their damages are $250,000, and we believe the terms and conditions apply. So that's a bridge too far, unfortunately. Not for lack of cordiality between the attorneys, but it's just a fact.
Okay. Anything else, guys?
That's it. Thank you, Judge.
See you at trial.
Thank you, Your Honor.
All right, I think our next hearing is the default judgment in Progressive County Mutual Insurance Company. Is that right?
We are listed at 3:15, and I'm not sure what else you have on the docket at the same
Yeah,
time.
that's the 3:15 hearing. Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 2319230, Progressive County Mutual Insurance Company versus Tahitian Pools. Counsel, make your appearance.
Yes, my name is Anna Peel. I represent Plaintiff Progressive County Mutual Insurance Company.
Okay. All right, you may proceed.
Yes, Your Honor. Progressive is the plaintiff in this case. It's an insurance coverage dispute. We sued seven different defendants, but only one has not appeared after being served. So that's the only one that's before the court. His name is Irvin Oliverio, and he was the driver of a commercial vehicle. And the vehicle was insured by, there's a commercial insurance policy for the company he was driving for. So Progressive insured the company that he was driving for, Mr. Oliverio, in this accident. And his passenger and folks in the other vehicle have filed claims. But the problem is that with the insurance policy actually canceled for non-payment the day before the accident. And then the accident occurred the following day. And then some hours or two later, the company, Tahitian Pools, called to try and reinstate coverage after the fact. And that creates, that's several problems. One is that the policy was not enforced when the accident happened. Another is that there was a lack of fortuity because, you can't insure something that's already happened. Another was fraud and misrepresentation because in that phone call to reinstate the policy, the Tahitian Pools representative said that there hadn't been any accidents, even though there had. And then finally, there's a failure to cooperate because in investigating this, Progressive tried to get the examination under oath of a representative of Tahitian Pools, and they never showed up. So again, this is only as to, now Tahitian Pools is a defendant and as to two representatives of the company, but they've answered so that this default judgment doesn't have any impact on them whatsoever. This is just for the driver. But the facts that I just ran through, those are the ones that are in our petition. So for purposes of the driver, those are admitted. And now we're seeking to get declarations from you, a declaratory judgment, just as to the driver.
Did you notify is there an underlying lawsuit here?
No, this is the law. No, this is the only.
I mean, is there a
right
lawsuit
now,
on the tort claim?
No, no, they're just claims at this point.
Okay.
This is just straight coverage. And the Tahitian Pools and the Prizalicki's, they're the ones who own the company. They answered, and their attorney was notified of this hearing.
Okay.
But again, we're not trying to hold any facts against them because, they can defend themselves on that.
All right, sounds good. I've signed the order.
You ever see a proposed order there?
Yeah, I saw it. I signed it and forwarded it to the clerk. You have a great rest of your day.
Okay, thank you so much. Have a great day, Your Honor.
Good afternoon, everyone. Hopefully I'm not interrupting anything.
Nope, you're good.
Excellent. Thank you, Judge Hoffman. Now I know that my volume works.
All right, are both sides here on the Mary Jean Michelle versus Valley of Bentry owners case?
Yes, Your Honor, for the plaintiff, Aaron Cartwright, and I believe that Mr. Trainer, yes, there's Mr. Trainer right there.
Yes, Philip Trainer for the defendants, Your Honor.
All right, Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 21-14025, Michelle versus Valley of Bentry Condominium Owners Association. Counsel, make your appearances.
Thank you very much. Your Honor, my name is Aaron Cartwright for plaintiff, Mary Jean Michel.
Philip Trainer for Valley of Bentry.
All right, let's proceed.
Thank you very much, Your Honor. And briefly, none of this is like I'm mildly irate and slightly ired about this, but none of this is Mr. Trainer's fault. He was not counsel at the time that this was in your court last year. But just a brief recitation of the essential facts. This was the case that came before your court in October of 2023 regarding Miss Mary Jean Michel, who you see right here, against her condominium owners association for repairs that they had failed to make since 2015. When this came before your court, parties reached settlement, and Your Honor had us read our settlement agreement into the record, as well as everybody make their affirmations of agreement to that settlement agreement in October. There was some small delay until around December 15th, 2023, wherein a written copy of the order was drafted and sent to the court for signature. I believe that the court signed that either on December 15th or December 26th, but in no event has there been, anything off on the court. So we have an agreement, we have a final order, and what we're seeking here now, Your Honor, is the simple fact that this unit has been uninhabitable since 2015. It's what started this lawsuit back in, I don't even remember what year, 21 or whatever case number that we have here, but it's what started this lawsuit back in 2021, what your court resolved in October of 2023, and to date, we have not seen an iota of movement from the condominium association regarding getting a contractor out to begin repairs. It has been 6 months. While I understand the condo associations, or maybe the condo association wanted a signed order before they began work, even though we all agreed on the record that the work needed to be done and was going to be taken care of by the condo association, that still doesn't excuse the fact that between October of 2023 and May 15th of 2024, there has been exactly zero movement to get this condo back in livable condition. Ms. Michel continues to pay $320 some odd each month for those association fees, as she has been for the past 10 years without that place to stay. All right. Furthermore, we have attempted to contact counsel's office, and again, this is not Mr. Trainer's fault. Mr. Trainer wasn't counsel, but we've sent messages, emails to Mr. Trainer's office. I have actually instructed my office to send Mr. Trainer an email every single day asking for a status update from the condo association on when we can expect a contractor or someone to get started with the work, because it's not just work. There's engineering that has to be done because there was a structural wall that was damaged during the repairs back in 2015. It's engineering, it's mold testing, there's supplies that need to be ordered. It's a lot of everything, and no one has contacted us yet to state that any work would be done inside of the unit. We did get something from Mr. Trainer saying that the condo was requesting unfettered access into the unit, and ordinarily that would be fine. We had talked last October about restricting access to between, I think it's 8 a.m. and 6 p.m. For purposes of making sure that Ms. Michel has a way of securing the door before those hours and after those hours. We've come to find out that even after the association requested unfettered access, that the association's own bylaws state that the construction work has to start, I believe, around 9 a.m. Don't quote me on that one, but I know that it has to end by 4:30 p.m. So in my mind, there's not an actual discourse around when they can access because the association's own bylaws give them the times that construction may occur. So where we are today, Judge, plaintiff, we're asking for an order from this court stating that construction must begin within the next 30 days. This has gone on for way too long. And I also do not know. I mean, I know that Your Honor may not give advisory opinions, but some guidance may be in order. I don't know if the final order that you signed is enforceable via any other method besides this right here, because I'm tempted to, if this is just a settlement agreement that parties reached, I'm tempted to sue them again on breach of contract because this is insanity that we're dealing with here. So again, before we get to the new lawsuit, before we get to additional sanctions, we're just asking the court if you can order the association to begin the steps required within the next 30 days.
Okay, Mr. Trainer.
Sorry, Judge. Thank you.
That's okay.
Thank you, Your Honor. First of all, my client does intend to complete the repairs as agreed. There were some delays between the October agreement and when the order was finally entered. My client was waiting for an order to be entered before any work would begin. Work has not progressed timely. I'm not going to dispute that fact. My client has every intention of completing it as agreed, though. Simply at this point, we're trying to iron out when they can have access to the unit. As the plaintiff is not currently living in the unit, there's no justifiable reason to limit when contractors and the association are able to come in and inspect work and complete that kind of thing. My clients, the board of the association, are all volunteers. They all have full-time jobs. If they need to meet a contractor in the evening to go over the next day's work or something like that, you know, it's simply not tenable that they don't have access after 4:30 in the afternoon or after 6 o'clock p.m. But all that being said, my client fully intends to comply with the court's order, and I believe we are moving towards getting that ironed out as to when it will begin.
So, Mr. Trainer, obviously, this is, I think you'd understand Mr. Cartwright's concern here. So how do we move this forward? Do you have your client here?
Not presently, no, Your Honor.
Okay. I mean, there's a variety of ways we could proceed with this. We could proceed the way Mr. Cartwright said, is he could sue for breach of contract. They could do a turnover order and try to take over the condominium association, I guess. They could do a contempt, potentially. I mean, I'm a little concerned that this seems a bit like a daisical that you don't have your client here. Do you have the ability to have them get on Zoom, or what do you want to do?
I don't know at this point. I don't know that I could produce him this afternoon, Your Honor. As I stated, my client has a full-time job and was not intending to appear this afternoon, so I don't think he's prepared to do so.
Well,
And briefly, Judge, we received this communication about the access last week. And again, if that was something that was stopping them, we could have had that discussion ages ago beforehand. As you saw in the motion, we've been attempting to contact Mr. Trainer's office or the condo association. Again, Mr. Trainer's not necessarily at fault for a non-responsive client, but we've been trying to get in contact with these folks now for months. January or February, whichever one is the earliest date that was stated on the order. If there was anything that we could iron out, such as time of access or an order or something, we could have resolved that. The order was resolved in 2023. Access wasn't brought to our attention until recently. I don't believe that there's a contract even in the works or a contractor that's been engaged on this property.
Is that true or not?
No, that's not accurate, Your Honor. My client has hired contractors. They don't have a work date established, but they're contractors my client has used in the past, and they are already on board with this project.
Ms. Michelle, you wanted to say something?
Oh, I was just gonna say that there's a ring system on my unit, and like no one's come in to inspect to get ready for anything to happen. That was all. There needs to be an engineer to come in to look at the severed section of the beam that's out, and and I think we can get whatever time, because I did not present this as set in stone when I gave the key to the management company. If there's exceptions to be made or whatever to work out, okay? But I would rest comfortably knowing that my security system is set for the evening. When I retire, I live in Aubrey.
That's another thing. We actually turned over the key to the association last October or November, almost immediately.
December 27th. On December 27th, I came in to give it to them. They said they couldn't accept keys. So later they contacted the attorneys, and I put the key, they got the key at the beginning of the next week then.
So at the end of 2023, the association has had the ability to access it, and no one's shown up to the Ring doorbell.
I mean, so let me just say this, Mr. Cartwright. So I feel that, or not feel it, I think you've filed probably not the correct procedural device to move this forward. I am just as concerned as you are that this hasn't been done. I do think that it would require, and this could be incredibly disruptive, I understand, to the condominium association, but they can't just ignore court orders. But, a contempt order, or because there is a court order in place, or a turnover order or something, Mr. Trainer, you just seem very, very lackadaisical about this, that you're not concerned that your client's not complying with court orders. And so I don't like these things to escalate, because it's never good for anybody. It's not good for Ms. Michelle. It's not good for the condominium association, but they should be taking this a lot more seriously than they are. And so I guess that's kind of my thought on it at this point. But I would advise your client that, look, they could be subject to jail time for violating this court order. Potentially, they could be potentially subject to fines. They could be subject to the entire condominium association assets being taken away. You can't just ignore court orders. I mean,
I completely understand, Your Honor, and I will convey the seriousness of the situation to my client.
All right. Well, good luck, Mr. Cartwright. You figure out what the correct procedure, or what procedure you want to pursue. I think you could potentially also sue for breach of contract. I think this is actually a judgment, so I don't know that I think you'd be kind of taking a step back if you do that, but do what you feel is best, and let's get this thing done.
Your Honor, I'll represent to you all, or I'll represent to both the court, to Mr. Trainer, that when we originally sought the enforcement, we wanted to have that within 30 days. So I'll tell you guys right now that if we don't have any movement within that 30 days, and I understand that Your Honor can't, sign an order based on what was requested, but if we do not see any movement here within 30 days, I will file that back with Your Honor, and then we can kind of move forward in that direction, fully understanding that Your Honor can't sign an order here today.
Okay.
Does that make sense?
I think so. So yeah, you guys have a great rest of your day, and I hope this gets worked out. I really think it's in everyone's best interest to get this gets worked out voluntarily, because it's not really in Miss Michelle's best interest to own a portion of the condominium association, or putting one of the, whoever the president is of the organization in jail.